Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. As I have started with a series on the company law, and in this series I have discussed history of the company legislation in India. Today in this video I am going to discuss one more important question relating to the company law, that is meaning and nature of the company. The word company ordinarily means a group of persons associated for the common purpose such as business, charity, sports, etc. The word company has no strictly or technical legal meaning in the terms of Company Act. As per Section 2 Clause 20, company means a company incorporated under the Company Act and any previous company law that is known as company as per Section 2 Clause 20 of the Companies Act. In general, company is an artificial person that is created by the law and that has a separate legal entity, perpetual succession and the common seal, and has the limited liability. In common law, company is a legal person or the legal entity separate from its members and capable of surviving beyond the lives of members and capable of having rights and duties of its own. If we talk about the meaning of the term company, the company may be described as an association of persons associated for some common purpose, common object. The purpose for which people may be associated is economic purpose. For company that is to carry on a business for gain, for earning the profit. In common sense, the company may be described to mean voluntary association of persons who have come together for carrying on some business or sharing of the profit. If we talk about the word existing company means a company formed and registered under any of the previous company law. If we talk about the more definitions of the company, we can take the definition of Professor Haney. According to Professor Haney, a company is an incorporated association, which is an artificial person that is created by law, having a separate entity with a perpetual succession and the common seal. This is the definition given by Professor Haney. And another definition that is given by Chief Justice Marshall. According to Chief Justice Marshall, a corporation is an artificial being, invisible, intangible, and existing only in the eyes of law. Being a creator of law, it possesses only the properties which the Charter of the Companies Act, by which it is created, confers upon it. Hence, a company to which a Companies Act applies comes into existence only when it is registered under the Companies Act. On registration of a company becomes a body corporate and legal personality of its own that is separate and distinct from its members. A registered company is therefore created by the law, and the law alone can regulate, modify, and dissolve it. If we talk about the nature of the company has a certain essential characteristics. First is incorporated association. Registered company must be incorporated or registered under the Prevalent Companies Act. It is compulsory as per Section 464 of the Companies Act for all the associations or the partnership of more than 50 members to register the under Companies Act. It is essential as per Companies Act 2013. And the second essential characteristic of the company, that is corporate personality or the artificial legal person in the eyes of law. From the date of incorporation of the company becomes a separate legal entity that is distinct from its members and that is recognized by person in the eyes of law. That is recognized as person in the eyes of law. This means a company is an artificial legal person which is created by the law and the law alone can dissolve it. It is invisible and intangible and exists only in the eyes of law. It may purchase and sell the property. It may enter into the contract through the natural persons. It can sue and be sued by others. It may be fined for the contravention of the provisions of the Companies Act. That is why company is known as legal person in the eyes of law. And the third characteristic of the company, that is the separate legal entity. A company is a separate legal entity in the eyes of law as distinct from its members. It does not lose its individuality by issuing the bulk of capital to one person only. It can sue and be sued not only by outsiders but also by its own members. In England, separate legal entity of the company was recognized for the first time in the case of Solomon versus Solomon and Company Limited in 1897. In this case, a person who was called as Aaron Solomon, a merchant, decided to form a company to purchase its own business. A company in the name of Solomon and Company was framed, was incorporated, and the subscribers to the members of the company were Solomon, his wife, his daughters, and his four sons. And the business of the company for rupees 38,782 was purchased. In payment, Solomon took 20,000 rupees shares of 1 rupee each, and the debenture worth rupees 10,000, and the balance was paid to him in the cash. And the Solomon was appointed as the managing director, and his two elder sons as a director of the company. Because of the depression and strike in boots trade, company was wound up. On winding up, the assets were worth rupees only 6,000, and the liabilities were worth rupees 17,000 rupees. As a secured debenture holder, he was given the priority over the unsecured creditors. It was contended on the behalf of unsecured creditors that the company had no separate existence, no independent existence. It was mere the agent which was working for the Solomon. The trial court gave the judgment against the Solomon and in favor of the unsecured creditors. But this judgment was reversed by the House of Lords, by the Court of Appeal, and gave the judgment in the favor of Solomon. It was held that the Solomon and Company Limited was a real company, fulfilling all the legal requirements. As a company has separate legal entity distinct from its members, and company is having a separate legal entity independent from Solomon, that and was not the agent. In the another case, in the Lee and Lee Air Farming Company Limited in 1861, Lee formed a company in the name of Lee and Air Farming Company Limited. Out of 3,000 shares, Lee himself was holding 2,999 shares and was sole governing director of the company. He was also appointed as the chief pilot of the company also. While piloting the aircraft of the company in the course of business, he was killed. He was held to be a workman and his widow recovered compensation under the Workman Compensation Act. Privy Council held that Lee and the company were not the one and the same person. Relationship between the Lee and the pilot and the company was that of the master and the servant. Thus, we can say that in the case, separate legal entity of the company was recognized. And another characteristic of the company, that is the limited liability. One of the principal advantages of the incorporated company is the privilege of limited liability. It is the main feature of the registered company. It provides special attraction towards the investors. It provides special attraction to the investors. Principle of limited liability implies that the liability of the members of the company is limited to the extent of unpaid value of the shares held by them. Thus, the liability does not fluctuate but remains limited to the unpaid amount of the shares held by them. For example, if a shareholder has 100 shares of a company, 10 rupees each, and he has already paid rupees 500, means rupees 5 for each share. So the unpaid value, that is rupees 500, and therefore liability extends up to rupees only 500, that is unpaid value of the shares held by him, and nothing more than that. But the company itself, being a legal person, is fully liable, and the company's liability is unlimited. That is, it is liable to pay debts so long as assets are available with the company. There may be a company with unlimited liability also, and a company limited by guarantee also. In case a company limited by guarantee, the liability of the members of the company, that is limited to a specific amount mentioned in the memorandum. And another characteristic of the company, that is perpetual succession, means company never dies. An incorporated company never dies. It is an entity with the perpetual succession. Even all the member dies, company still alive. The life of the company does not depend upon the death of the members, insolvency of the members, or retirement of the members, or the directors of the company. It is creation by law. It is the creation of law, and the law alone can wind up the company. Law alone can wind up of a company. It is creation of the law, and law alone can wind up a company. And the members may come and go. Members may come and go, but the company go forever. Professor Kovar had also said that during the war, all the members of the private company were sitting in a room for a general meeting. They were killed by a bomb blast. But the company survived. Not even a single member was alive. So this means company never dies. We can say that company never dies. Even all the members may die. Does a company has a perpetual succession? Means company never dies till it is wound up by the act, by the statute by which it is framed, by which it is registered. In the case of Gopalan Tea Company Limited versus Penlock Tea Company Limited, Honorable High Court of the Calcutta applied the doctrine of the company's perpetual succession and observed that whole undertaking of the company was taken over under the act. And the another characteristic of the company, that is transferability of the shares. In the case of public limited company, the shares are fully transferable without seeking any permission from the company or the other members. In the case of private company, there are some restrictions on the transferability of the shares. And the next characteristic of the company, that is company can sue and be sued. A company being a body corporate or the legal person in the eyes of law can sue and be sued in its own name. It has a capacity to sue and be sued. More characteristic of the company, that is separate property. A company being a legal person is capable of owning and enjoying and disposing of the property in its own name. The company becomes its owner. Company becomes the owner of its capital and assets. The shareholders are not the private or the joint owners of the company property. The company is the real person in which all its property is vested and by which it is controlled, managed and disposed of. And another characteristic of the company, that is finance. The company is the only formation of the business organization which is given the privilege of raising the capital from the public by public subscription, either by way of shares or by way of debentures. So this was all about the advantages or the characteristics of the company. And another point, that is disadvantages of the incorporation or the company. If we talk about the disadvantage of the company, first disadvantage, that is formality and the expenses. Incorporation is very expensive affair and requires a number of formalities that must be complied with. A number of documents are to be filed with the registrar of the companies of the state in which registered office of the company is situated. Stamp duty, registration fee and filing fee, these are also paid at the time of formation of the company, which is very expensive. This means the companies are alone required to some annual reports also to the shareholders and various types of information to the registrar of the companies. The winding up of the company is also very expensive and low procedure. Thus we can say that formation of the company, that requires a various formalities as well as it is very expensive procedure. That is disadvantage of the company. And another characteristic of the company, that is loss of privacy. A public limited company is required to publish the constitution, capital structure, final accounts, etc. by filing the prescribed documents with the registrar of the company. Thus, there is a loss of privacy in the case of companies. As we are saying that company is a separate legal entity, that is a person in the eyes of law, that also have a privacy. Every person is having the privacy. But here the privacy of the company is lost as all the information regarding the company is published. We consider there is loss of privacy in the case of company. And another characteristic of the company, that is corporate governance. In a public company, in a public limited company, there are large number of shareholders who can't take part in the management of the company. Thus, the powers of management are exercised by the directors who are elected representative of that shareholders. So, in the actual practice, in many cases, management has a power. In the actual practice, in many cases, management has a poor track record of corporate governance And this is one of the disadvantage of the company. Another disadvantage, that is the liability of the directors as well as the shareholders. The act also imposes the personal liability on the directors or the members of the company in the certain cases. And this is also one of the disadvantage of the company. And the another disadvantage, that is the lifting or piercing of the corporate veil. The chief advantage of the incorporation separate legal entity of the company, the business of the legal person of the company is carried on by or for the benefit of some individuals. In the ultimate analysis, some human beings are the real beneficiaries of the corporate advantage. By the fiction of law, a corporation is a distinct entity, yet in reality it is also association of the person. It is an association of person who are benefited, who are the beneficial owner of all the corporate property. Thus, a company is a legal person which is distinct from its members. Company is having a separate legal entity distinct from its members. Thus, the principle may refer as the will of the corporation. Hence, there is a fiction will between the company and the members. The famous Solomon case established the existence of the will of the corporate personality. In this case, the separate legal entity of the company was recognized for the first time, and the complete separation between the company and the members has never been doubted. In 10 cases, will is lifted and pierced to identify the members behind that company. Corporate will is said to be lifted when the court ignores the company and concerns itself directly with the members or the managers. So the lifting of the corporate will means disregarding the corporate entity of the company, means seeing the real beneficiaries of the company who was taking shelter behind the wheel of that company. So there are the certain circumstances when the corporate will of the company can be lifted. Means separate legal entity of the company can be disregarded, and it can see who are the real beneficiaries behind that corporation. It can be classified under the two heads. First is under the judicial interpretations, and the second one is under the statutory provisions. So this is also one of the most important questions for the examination point of view, where it is only asked, describe the circumstances when the corporate will of the company can be lifted. It can be asked for 20 marks, and it has been asked in the previous year exams for many times. I will discuss it in the another video, next video. And if you have any doubt, then you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.